Ladies and gentlemen, today I want to dissect the legal gymnastics, and I've chosen that word on purpose. The legal gymnastics in light of Dr. Besigye's continued detention, particularly in the context of what has ensued before court today in light of a transfer from the court martial to the civilian court. If the government continues to deny substantive individuals, whether Besigye or any other person, the opportunity to create that substantive transfer, in spite of the Supreme Court ruling that pronounced itself vehemently that all civilian entities be transferred to civilian courts, then we have some issues to dissect in terms of constitutional violations. Let's look at the violation to the right to personal liberty as provided for under Article 23. When you argue Article 23, Sub-Article 1 of the 1995 Constitution, it guarantees the right to personal liberty unless lawful detention is actually justified. When you argue in light of Article 23, Sub-Article 2A, it allows for an accused to apply for bail, and any refusal must be based on a strong legal justification. So the problem today, if the government, for example, routinely denies bail without valid reason, this becomes a disguised form of an indefinite detention, and that's something that we may want to look up in terms of justification. When you address the case of Chamanya versus Uganda, the Supreme Court ruled that detention without justification violated constitutional rights. And if you're arguing in light of what they call arbitrary detention, contrary to international law, we would provoke the African Charter on Human and People's Rights, particularly Article 6, and the International Covenant on Civil and Political Rights, what they call the ICCPR, particularly Article 9, that prohibits arbitrary detention. And we're also looking at whether or not Uganda is actually bound by these international obligations. Obviously, the question is in the affirmative, or the answer is in the affirmative, that Uganda, yes, is bound by these treaties, and denying bail on flimsy grounds could trigger international condemnation. For example, in the case of Tanganyika Law Society versus Tanzania, the African Court ruled that prolonged pre-trial detention violated human rights in that perspective. So the idea that I would like to propound in light of the denial of bail to some people can be argued as a political tool. And the question is whether or not courts ought to consider health conditions under Article 23, Sub-Article 6, but denying bail despite Besigye's frail health and even hunger strike raises questions of selective justice. And in a minute, I'll try to make a dissection in light of the so-called hunger strike as well. And then the government could actually be using legal procedures to suppress political oppositions rather than upholding justice, because you have been evident as witnesses of what has been transpiring. The civilian court maneuver, for example, as a legal gymnastic move, could also be a question of suspicion, because government's decision, for example, to remand Besigye in a civilian court rather than a military court, one could actually understand it as something to do strategic legal gymnastics in terms of a move designed to evade perhaps the Supreme Court ruling on the unconstitutionality of the court martial as pronounced by the Supreme Court. So one wonders, if court has pronounced itself, especially the Supreme Court, if the Supreme Court of Uganda has ruled that civilians cannot be tried in military courts, then that, in my opinion, is evident enough. Why? If you argue that Besigye's lawyers are the ones who delayed to extract the decree, and yet we all know that Supreme Court orders are self-executing. And if it's a question of, executing or perhaps even, getting the decrees, it's inter partes. So any of them could have actually extracted the decree in this particular context. So I would argue that these are possibly tactical moves that probably to ensure continued legal entanglement while maintaining a facade of due process. And therefore, it's suspicious. It smells with malafide. And so to avoid why they may have done that, to bring Besigye, because obviously habeas corpus is a non-derogable right, and to avoid direct constitutional violation, they create a seemingly good effect. But the idea is to perhaps create a prolonged detention without direct, breach of the Supreme Court precedent, because then that would augur badly in light of constitutionalism, but also in terms of international perspective. So by keeping Besigye in civilian detention, but constantly denying bail, and the state achieves the same control over him without actually using outright constitutional military trial, which he had already, had anticipated to undergo. And then if you argue in light of the health factor, the argument of, I would argue in terms of what they call the legal time bomb as a health factor, the violation of the right for protection from inhuman treatment under Article 24 and 44. When you look at Article 24 of the Constitution, it prohibits torture and inhuman treatment. And that is something, again, we cannot run away from. When you look at Article 44, it also makes it a non-derogable right, meaning it cannot be suspended under any circumstances. And that's why you saw government, agreeing with the order, the order to make sure that they bring the body, the habeas corpus order. So the idea is that now that the body has been brought, so what? So if Besigye's trial is also defeated on aspects of denial, bail denial, in spite of vehemently pictures portraying him in such a sorry state in terms of his health, then we have a problem. When you look at the case of Attorney General versus Susan Chigula, the court ruled that inhuman treatment, including exposure to suffering in detention, violate constitutional rights. And these are some of the things you may want to bring to bed in light of constitutional dispensation today. The question is, can a further remand be justified in the context of what has happened to Besigye today? Government can lawfully remand somebody only, under certain specific conditions. For example, if they are at risk of absconding, if the state can prove that Besigye is likely to flee justice, then maybe they can say, okay, wait a minute, we are not ready to grant you bail on that condition. How about if there are instances of ongoing investigation? There are instances, for example, where they can say, wait a minute, there is a genuine reason for not, granting you bail because we are still investigating the matter. But we are moving under the assumption that the court martial had done their part and Besigye was due for trial. And then these strategic and institutional challenges bars the move from the court martial to the civilian court is also creating delays and challenges. And then if there are national security concerns that are legally justified, then that can also be raised. So the problem, if the state cites these reasons without clearly bringing out evidence, then the move becomes a legal abuse of process rather than a genuine, judicial decision, and that doesn't augur well in light of judicial jurisprudence of this country. In the case of Uganda Law Society, for example, versus Attorney General, the court ruled that detaining political opponents under vague security claims is actually unconstitutional. So when we hear people saying that, first of all, the delay had to do with the failure of Besigye's lawyers to extract, a decree, we all know that and Supreme Court decisions are self-executing, and besides, the question was a question of inter-party, so any of them could have actually gone and extracted this decree. So we cannot, keep playing cat and mouse on an entity whose life is actually at the mercy of the powers that be. So the High Court and Constitutional Court can review the question of bail as redress, in fact, by citing Article 23, Subarticle 6. But also another option could be petitioning for a writ of mandamus, for example. Bessigye's lawyers could actually file a writ of mandamus to compel government to, in terms of compliance with constitutional obligations, and those are some of the remedies that we're looking at in terms of a dispensation of trying to analyze, to dissect the situation that it was. And obviously, the aspect of challenge for selective justice. If other detainees in similar situations are actually granted bail, but Besigye is denied, then this can actually be challenged under Article 21 of the right to, equality before the law. And then, so these are substantive aspects. So my point here is, even as we address this dilemma that we are facing as a country, the classical case of legal gymnastics comes into play. The government's actions appear to be legal on the surface, but serve a deeper political purpose. And the use of civilian courts instead of military courts as a move to avoid, outright illegality. Yet the repealed, bail denials or repeated bail denials suggest a strategy of prolonged detention without formal charges. I wouldn't be surprised if the honorable gentleman is actually denied bail on substantive petty issues in spite of his health. And I will address the health aspect in light of a right to his health, So the denial of bail, despite his frail health, is a potential inhuman treatment, and it's captured under Article 24 and also 44. So the argument here is that the legal maneuvering to keep Besigye detained creates a potential of judicial abuse as a process, and therefore shifting to civilian courts to bypass Supreme Court ruling, in my opinion, becomes a tactical legal gymnastic. And that is something that you must comprehend. They are saying, okay, you put us at arms, you've asked us for the body, habeas corpus is non-derogable. As a question of law, we have produced the body, but so what? Now how do we proceed? So ultimately, Bessigye's legal team can actually challenge these actions in Uganda's court, or escalate the matter by invoking international human rights bodies, and government liability, for example, can also be ensued or called upon in terms of Besigye's hunger strike. I will give a legal analysis in terms of that. There are those who wimp it or wish it away and simply say he is done starving himself. But listen, if Dr. Kizza Besigye continues his hunger strike voluntarily, the Ugandan government could still be held liable under certain legal principles, particularly the duty to care and protect from inhuman treatment and the right to health in detention. The reason why people do take that option rather than using violent means is to, signal the populace or whatever the powers that be that we are not comfortable in these positions because the law is not being, fairly treated on us. So there's a duty of care. The state obligation in terms of protecting these detainees. Once a person is a state custody, then the government assumes a legal duty of care over them. So even if the detainee initiates hunger strike voluntarily, the state must take reasonable steps to prevent severe harm or death. And this is substantive jurisprudence, by the way. This is not a question of hearsay. When you hear people saying, no, wait a minute, he's just simply calling for sympathy. No, my friend, failure to do so could amount to inhuman or degrading treatment violating Article 24 and 44 of the Ugandan Constitution. You just can't rub your shoulder and shrug it away. These are questions of law, and these are questions of constitutional jurisprudence that we have to align ourselves with. I'll provide some substantive case law to enforce what I'm trying to say. In Soaring versus UK, which was a 1989 case, the European Court of Human Rights, said that a state has an obligation to prevent foreseeable harm to a detainee, even if self-inflicted. So that right or that obligation still falls on you, the state. In Attorney General, for example, versus Swedish and 14 others, the argument here, the Supreme Court made a sound, invocation by making that Uganda must uphold the minimum human conditions for detainees regardless of their actions. So regardless of Dr. Besigye's actions, the fact that he chose that avenue is not because he feels like, wait a minute, I want fasting a little bit. It's because he has seen a miscarriage of justice and is invoking whoever can, understand the application. So violation of protection in terms of Article 24 and 44 becomes a question of importance. Article 24 of the Ghana Constitution prohibits torture, cruel and inhuman or even degrading treatment. Article 44 makes the protection non-derogable, just like the writ of habeas corpus becomes non-derogable, meaning it cannot be suspended under any circumstances. Think about it, not even under emergency orders, even during a hunger strike, you cannot suspend that right. It is non-derogable. So how then does this apply in light of Besigye's case, for example? If the hunger strike leads to a serious health condition by way of deterioration and government fails to intervene, it could actually be seen as state negligence. Think about a person who wants to commit suicide and lo and behold is apprehended by a police officer. Why do you take them to court? You take them to court because even though they are not interested in their lives, the state is actually interested in them. So even in this particular case, even if Besigye refuses food, the state is obligated to provide medical attention and perhaps address some of those anomalies that are causing him to do that. Besigye is not mad that he's simply saying, wait a minute, let me go hungry and then they take me back home. No, he is aware that there are legal machineries that are supposed to do these things. If they are not there, then there's a problem. Look at the case of Ireland versus UK. The European Court of Human Rights said inhuman treatment includes neglecting the medical needs of the detainees. So the fact that Uganda's international legal obligations are bound onto us as Ugandans. The International Covenant on Civil and Political Rights, for example, the ICCPR, particularly Article 10, requires that all persons deprived of their liberty shall be treated with humanity and with respect for their dignity. You just cannot run away from that. So much as we are excited that the habeas corpus worked out, you have to take it with a pinch of salt and wait a minute and say, maybe they have no redress. Look at the African Charter on Human Rights and People's Rights, especially Article 5. That prohibits any form of inhuman treatment in light of punishment, in terms of including deliberate neglect of detainees, in terms of health condition. Government was aware that there is no way they could beat the habeas corpus application. In spite of the delays, the dilly-darlings, the saying that if the lawyers of Besigye did not take up arms, did not extract the decree, this decree by the Supreme Court is self-executing. So it was any of them, it was inter-party, any of them could have actually proceeded and gone ahead. And then this argument that Kizza Besigye is actually striking or hunger striking because he wants to appeal sympathy, that's not the case. Hunger striking case, look at the hunger striking case of Turkey 2000. The European Court ruled that if the state allows the detainee health to actually deteriorate without intervention, it amounts to inhuman treatment. So I am aware that Dr. Besigye has actually visited medical, personnel, has been taken for medical, appraisals, but substantially whether or not that will solve the problem is the question of the day. And we are also perhaps seeing the better light in a sense that now we are now seeing a process taking place, but you see there are substantive issues that government faces in light of this paradox. If we force Besigye, for example, to feed, this could violate his rights to dignity and in terms of bodily autonomy as well. Letting him suffer without intervention could actually violate the right to human treatment also. So the only legal course, in my opinion, would simply do the right thing. I think it was Edward Bank who said the only thing necessary for good men for evil to triumph is for good men to do nothing. Simply release him on medical grounds and incarcerate him in his home, perhaps. Give him conditions that are stringent enough, but make him comfortable. Don't hold him culpable to situations that actually continue to deteriorate his life. You have done that before. So ensure medical oversight in terms of human conditions and detention. Besigye's voluntary hunger strike does not absolve the government of its duty of care. You just can't wimp that away. You just can't simply shrug it off and say it's a question of him. So failing to act could amount to human rights violation as seen in past international rulings. Yes, so the Ugandan courts and the human bodies could hold the state liable for neglect even if the hunger strike is self-imposed. That is something you just can't run away from. So, as I said, we may be happy that now we have seen a transfer from the military court to the civilian court. But then what is the question? Are there strategic challenges, institutional challenges, for example? When civilian courts want to procure a matter, how do they start? They have to do investigation by the police, by the investigating officers, for example, by the DPP, by the sanctioning of these files. Have these things been done under the civilian court? Have there been a substantive transfer of file, for example, from the court martial to the civilian court? Because court martial does their things in a different way. They have the CMI, they have the ISO, they have the SO, they have all those arguments. So they probably have things on another platter. Now we are saying it's important. Are we going to start on a tabula rasa in light of what is happening now in the DPP? Okay, if we are saying that investigations are still continuing, can we release the suspect pending investigation? All those are plausibilities. Can we grant him bail? Do we have to send him back to court? Don't we have redresses in terms of these challenges? So even as we address this dilemma, we have to understand the political, legal dynamics of the Kizza Besigye dilemma today as we stand today. And I'm not really making advocacy for any particular thing other than being a drum major in terms of the rule of law, in terms of constitutionalism, in terms of sound judicial precedents that will augur well for this country and create a foundation that you and my great-grandchildren should be proud of one day. Thank you for your attention. Once again, my name is Isaac Christopher Lubogo. Find some of our works at lubogo.org and suegenerislawup.com. God bless you, and thank you for your attention.